Welcome to our keynote webinar for today, More Neutrals Are Better Than One, a progressive approach to alternative dispute resolution. Thank you all so much for joining us today. I'm Katrina Nobles. I'm the Director of Conflict Programs at the Scheinman Institute on Conflict Resolution in the ILR School at Cornell University. And today we've brought together an amazing panel, including our Institute's benefactor, Marty Scheinman, along with our distinguished panelists, Barry Peak, Julie Torrey, and Timothy Taylor, in honor of the one-year anniversary of our Scheinman Institute Employment and Labor ADR Hub. Just a little bit about the hub. The Employment and Labor ADR Hub was designed to be a place to discuss up-and-coming topics in the field through webinars, roundtables, and online discussions and networking that take place in our Canvas Hub site. If you would like to join our hub, please feel free to email me at kn64@cornell.edu. I would also like to thank all of our panelists for joining us today, and I'm really looking forward to the discussion. I would also like to thank eCornell, as well as my co-chair for the hub, Ellen Gallen-Presida. And with that, I'd like to hand it over to Marty to lead our panel discussion.
Thank you, Katrina. It's wonderful to be here, and we're glad you invited us. Ellen and Katrina thought that, I guess, the Scheinman from the Institute, in the honor of the anniversary of the HUD, which is a big deal, should give a talk about our practice of what we call the Scheinman Arbitration and Mediation Services. Also, you'll hear us refer to it as SAMS, that we think may be unique and might contribute to the discussion about how an alternate dispute resolution practice might operate in the 2020s. Rather than tell us about everybody's bios, we've agreed that bios will be in the chat, and so therefore you don't have to listen to the boredom of us droning on about ourselves. The neutrals at SAMS each have individual robust arbitration and mediation practices. They do investigations, but we also collaborate on many matters premised on the theory that several heads are better than one. This is in order to achieve the mission and our motto, which is excellence, experience, and results. We work together in recognition of the fact that given the enormous complexity of certain labor management negotiations, the interplay with government agencies like the EOC, the DOL, the Department of Health, the New York City Department of Consumer Affairs and Worker Protection, as well as the demands of multi-party arbitrations and mediations in the areas of sexual harassment, gender, race, orientation, age discrimination, whistleblowers, wage and hour, wage parity, staffing, all require an enormous amount of experience and, candidly, breadth. Especially in light of the fact that there are new statutory schemes like the Fair Work Week, staffing standards that were just passed by the legislature. We have concluded that a single neutral cannot adequately serve the parties' needs, in large measure because we think a team approach is often best given in order to respond to what the parties expect. So, for example, when you are confronted by pretrial discovery issues and the disputes that arise in real time, the reality is largely impossible is the thought that one person can handle this. And we also note that in large public figure or high profile type cases, the neutral is facing or interacting with parties that have multiple lawyers. So, for example, you might have law firms representing the claimant. You might have law firms representing his or her guardian, significant other, spouse, partners. You might have the individual defendant with a team of lawyers. You might have attorneys for the corporate defendant, attorneys for the insurance company, legal representatives, and sometimes lawyers from the government agency. Simply put, one individual in many of the cases we handle would lack the bandwidth to perform what is expected and what is required. Candidly, the lack of capacity also concerned me regarding quality. Receiving an urgent message from one of our administrative staff that parties in a deposition were waiting an immediate ruling while they sat around wasting each other's time and money, or an overnight discovery demand greeting my morning, persuaded me a new approach was needed. Merely dictating from my car, or the hallway, or sometimes the restroom, a determination while the parties in the matter I was handling at the very time were waiting annoyed me, was not the way to respond to real-time disputes. It has long been the case that arbitrators had legal assistants and ghostwriters, but many are done secretly without the full knowledge of the parties. I wanted a more public, collaborative practice. I believe sophisticated parties who themselves would bring 2 or 3 or 4 or more arbitrators or advocates to a dispute to appear would understand and welcome a team approach more able to respond quickly and handle all of their work product with timely rulings. It turns out our suspicions were correct. We also recognize that parties increasingly, when they had a dispute, were putting in those dispute resolutions or in their awards, ongoing dispute resolution, a process where they would ask the very neutrals to continue to build on their agreements or on their awards, to implement them, for example, staffing, or to implement some agreements that had been made, and to make sure there had been compliance. They didn't want to go to court, and they didn't want to go back into an adversary situation. They wanted that neutral to take on. Obviously, this required tremendous amount of manpower to be able to respond to these kinds of assignments. As you will hear, despite what I was concerned about, parties do not object to this system and have come to appreciate the fact, at least in our experience, there is always someone to respond and handle competently an issue. In fact, in many matters, while I was originally the person selected, they bring only the most sensitive issues to me. They know that there are people far better, more able, more engaged than I could do in this case, and they expect better. The idea of multiple neutrals working on a matter is not new. Many of the neutrals and people watching today have had the experience of a 3-person arbitration panel when all of the panelists are actually neutrals. Of course, many of you also have panels where there are party arbitrators and 1 neutral. But the model I admired was there were multiple neutrals assigned to an actual or threatened strike. I watched how that worked. Despite concerns, neutrals would step on each other. I found the opposite. Better ideas, easy division of responsibilities, and the ability to manage more of the incoming fire in these kinds of disputes. I was informed by the transit strike in 2005, which got a lot of attention. Richard Carreri, then the Public Employment Relations Board's Director of Conciliation, and a founding mentor, as I could say, and give a plug to the Board of Advisors of the Scheinman Institute, invited arbitrator Al Viani and I to join a team. Rick took the primary and the hardest role. He was dealing with the government, the transit authority, the city, the governor. Viani, given his strong union credentials from his prior life before he was in neutral, took the lead on the union side issues, the union politics, and how to deal with the membership. And I served as the regular neutral trying to settle the underlying dispute, the pensions, the healthcare, the money. The coordination, I became convinced, especially with years to assess it, is how we were able to resolve a strike and restart the subways and buses which had crippled New York City. Candidly, no one neutral would have had the stamina, the insight, the credibility, and frankly, the gravitas to find a solution. Strikes and other large impasse panel work also demonstrated the wisdom of having different viewpoints, experiences, and insights in complex disputes. In order to expand capacity, initially we built a state-of-the-art arbitration center with ample hearing rooms and technology. Space was created to have several neutrals and multiple matters being handled simultaneously. Initially, I invited my time friend Barry Peake, who had been a union side lawyer with years and years of arbitration experience, who was transferring to a neutral practice to become my partner. Shortly thereafter, Julie Torrey, a former management side attorney and a highly experienced litigator, who had started a neutral practice and had graduated from the Scheinman Institute's arbitrator training program, joined us. Finally, Tim Taylor, a successful arbitrator whose practice emphasized upstate New York and Massachusetts, was lured, that's the word I use, to transition into a practice that would be more involved in the downstate tri-state area. Forming this team had other propitious impacts. Our team would advance diversity in a profession that needs it and would serve as a real-life opportunity for training and collegiality in a profession too often siloed. This would also provide advocates the chance to cultivate relationships with the next generation of neutrals they need to serve them. I've often opined that it is the advocates that have to help make the neutrals if they want them to be there when they need them. At the same time, this progressive approach might further my passion of educating the next generation of neutrals, a founding principle of Cornell's Scheinman Institute. Barry Peek will speak a bit with you about how this process and this team approach works in labor management mediation. Julie will then speak about how this multiple neutral approach works in complex employment arbitration matters. Finally, Tim will address how multiple neutrals enhances employment mediation in the most pressing and difficult matters. After they finish, I'll talk a little bit about the cautionary issues, whether this is scalable and able to be duplicated or improved upon by other practices, how to introduce and acclimate parties to the possibility, even in traditional settings, like even Major League Baseball and their players, where I am now the permanent arbitrator, and how Zoom has provided even more opportunities for this kind of collegiality and team approach to ADR, and permits, frankly, us to do things we never imagined, have matters where people literally are in Europe, Asia, Africa, and South America. And lastly, I would like to talk, if we have time, about whether this is transferable to dispute resolution in non-employment settings. Is it possible that this is precisely what is necessary in order to make ADR what it needs to be as we approach what is going on in the world? With this, I turn over to my colleague, Barry Peek.
Thank you, Marty. Thank you, Katrina. I want to congratulate the Scheinman Institute Employment and Labor ADR Hub on its first anniversary. Thank you for allowing us to participate in marking this special occasion. My first exposure to the benefit of utilizing multiple neutrals was when I was still a practicing attorney representing the United Federation of Teachers in New York. As you may recall, when Mayor Bloomberg left office in 2014, there was no money in the budget set aside for a contract with any of the labor unions, including the UFT. Negotiations were not successful, and we then went to fact-finding. At the time that we commenced the fact-finding, the retroactive payments that were at issue just for the UFT amounted to approximately $5 billion. The prior contract expired in November of 2019. The UFT team, in addition to the members of the negotiating committee, consisted of 2 outside law firms, in-house counsel, representatives of the paraprofessional unit, which has a separate contract, representatives of the UFT grievance department, and various economic consultants. The city was represented by the Department of Education, the Office of Labor Relations, and the Office of Management and Budget. And at the fact-finding proceeding itself, the city was represented by outside counsel. And at least 4 attorneys from the Proskauer firm were present during the fact-finding. The fact-finders assigned to the case were Howard Edelman, Mark Grossman, and Marty Scheinman. The big surprise in that situation was that Marty was named the chair. All shocked. At the end of the hearing, which you know does not result in a binding decision, only a recommendation, the parties agreed to the chair's suggestion they engage in mediation in an attempt to reach a final agreement. And believe me, the issues before the panel were numerous and complex. For example, as I mentioned, $5 billion in retroactive payments. And in conjunction with the issue of wages is always the elephant in the room in the name of pattern bargaining. Since almost all of the municipal contracts were still unresolved, whatever agreement the UFT would be reaching would set the pattern for all other non-unified uniform city unions. Other issues were the teacher evaluation program, the alternate teacher reserve, otherwise commonly referred to as ATR or the rubber room. I made a mistake, it's absent teacher reserve, but that's okay. There was the issue of additional professional development, flexibility for schools. There was a program where if schools opted in, they can result in a different school day and greater teacher voice in hiring. They would not have to follow all of the contractual and chancellor regulations. There was the issue of excessive paperwork. Teacher leadership positions in the form of a master teacher. Curriculum was an issue. And there was the issue of the paraprofessional contract, which is, as I said, a special contract, a separate contract, and historically bargained simultaneously with the teacher agreement. As you could imagine, dealing with these issues was no easy task. The accounting issues regarding the retroactive wages, which one in and of itself took weeks to finally resolve after speaking about it and arguing about it for months. It became clear one mediator could not help the parties resolve the issue in a timely manner. At the suggestion of Chairman Scheinman, we agreed that each of the fact finders would be assigned various discrete issues to work in subcommittees with the UFT and the city representatives. It's important to note that these mediators weren't assigned randomly. Marty took the lead on the issue of retroactivity, which became the model of the city non-uniform contracts. Marty could do an entire seminar, I believe, on how that issue was eventually resolved and how complex it was. We all got an education in accounting principles during that hearing. Howard Edelman and Mark Grossman were assigned to subject areas they had prior experience dealing with it. Within a matter of weeks of around-the-clock meetings, an agreement was reached. Since we had 3 mediators with very busy schedules, we were at least able to meet with one mediator each and every day, and progress was made. If there was only one mediator assigned based on his or her schedule, it would have been impossible to conduct these meetings in a timely fashion. In retrospect, I have no doubt without the assistance of all 3 mediators, the parties would not have been able to reach a settlement. And if they did, it would have taken months or even years to resolve. And as an advocate, I welcome the process. It gave the parties a real structure to follow in coming to a resolution of the disputes. And we always felt that we had the full attention of each mediator that we met with throughout the process. They were fully engaged, and it was an example of how we could all work together and how the mediators were collaborating on a day-to-day basis. Now, let me turn to an example of when I became a neutral. I decided to leave my position at Meyer Swazi English & Klein in September of 2016 and join Marty's practice. It was the hardest professional decision I made, but the best one I made. Not only was Marty my friend, but in my mind, the most respected arbitrator in the country. When I first began, it was just Marty and me. The biggest adjustment I had to make was coming from a law firm where collaboration was the norm. I was now spending much of my time by myself, and I quickly learned I didn't even like myself that much to spend so much time with me. There was no attorney down the hall who I could speak to if I had a particular issue which was unique, or I just wanted to have another set of eyes on it. When Marty explained his vision for SAMS, I quickly thought of Julie Torrey, who I knew from my prior practice and from our time together at the Scheinman Institute. Then we added Tim Taylor. Just having people in the office who you can talk to, even if it's about logistical issues, has proven to be invaluable. When Neisner and the New York City Alliance of Hospitals had a dispute, Marty and I came in to help resolve it. This took place in 2018, 2019. The Alliance of Hospitals is comprised of Mount Sinai, Montefiore, New York Presbyterian, and Mount Sinai West, otherwise known as St. Luke's. Negotiations for that contract did not go well. After weeks, many weeks of mediation with two federal mediators, the parties were still unable to reach an agreement. After 97% of the nurses authorized a strike on March 19, 2019, and the union served the 10-day notice of a strike to take place on April 2nd, 2019. The hospitals then made arrangements to bring in thousands of nurses from out of state in anticipation of dealing with the strike. Hundreds of thousands of dollars would have been spent on that alone. Upon receipt of the 10-day notice, who would the parties reach out to? Marty Scheinman. Marty and I came to a New York City hotel, and we quickly learned of the significant global issues that were on the table, such as staffing ratios, staffing allocation, which simply, in simple terms, is the number of nurses who will be assigned to each particular unit. Pension was an issue, retiree health was an issue, and violence in the workplace. In addition, there were 4 separate local agreements, each with significant issues that had to be resolved as well for each of the 4 hospitals. And most important, Time was of the essence. The strike was just a few days away. Marty decided that the team approach would be necessary. Reasons why? The very, very short window until the strike date of April 2nd, the complexity of the issues, such as staffing, local issues affecting each of the 4 hospitals. Numerous attorneys were present and hospital representatives that we had to deal with. Each hospital who came to the meetings had their own law firm. The Alliance was represented by separate counsel. In all, there were 5 teams of lawyers for the Alliance hospitals. There were also numerous representatives of labor relations of each hospital, as well as nursing management. On the union side, on Neisner's side, they had union counsel, Neisner staff attorneys, representatives from each hospital. There were close to 75 individuals in total, maybe more. So when we first arrived, we were brought up to speed by both sides, as well as the 2 federal mediators. The first thing Marty was able to accomplish is to put out the fire, put off the strike, which was only days away. He was able to get the Alliance to assure the union that a certain amount of money would be set aside to deal with the real burning issue of staffing and staffing ratios. It was decided the best way for the mediation to be successful was for each of the mediators to be assigned a specific role. First, we had to resolve the global issues. In order to even get to the local issues, the global issues had to be resolved. That was the way Neisner handled their negotiations. And all of us would be involved with Marty leading those discussions. And in between those sessions, we would all meet, we would discuss the progress and next steps. Having the ability to collaborate with one another, I believe, was essential in our making our progress. Not only did we discuss issues, but we all developed separate relationships on each side of the table, which we discussed, and I believed helped us better understand the thought process that was evolving on each side. Once progress was being made with the global issues, Marty assigned each of us to one of the hospitals to facilitate the discussions for each unit. Again, these were complex issues: seniority, posting, schedules, floating, retirement, and an allocation committee. Each hospital would agree to a committee where they would sit down and allocate the number of nurses to be budgeted for each year. And at one point in the process, Marty was scheduled to be out of town for a few days. And since I was present and completely immersed in the process, the mediation was able to continue during his absence, and no time was lost. Of course, I was in contact with Marty throughout the day, bringing him up to speed as to the progress and if there were problems to be discussed. And that brings up the real main question of acceptance. From my experience working at SAMS, there's never been a problem of accepting having another of the SAMS mediators or arbitrators present. I found to the contrary. The parties appreciate the fact that if they couldn't reach Marty, who has a tremendously busy schedule, they could communicate with me, Julie, or Tim and get a response. They didn't have to wait that long. The parties are able to get quick responses to any questions that they have, either oral or written. There have been times when I've been called upon, because Marty was in an arbitration, to make rulings during depositions. But the parties know that Marty is being fully briefed and on every issue. And if you know Marty, you know how quick a study he is. In addition, he has an incredible memory of what you tell him or what anyone at the bargaining table or an arbitration says to him, even weeks later, which I am completely amazed of time and time again. So after spending a few weeks in this New York City hotel, the parties did reach an agreement, which was groundbreaking, and in that it resolved the staffing and ratio issues. In addition, the parties agreed, as Marty mentioned earlier, to continue a process of mediation and arbitration, especially in regards to the ratios and allocation of nurses. Instead of agreeing, which they normally would do, to just one mediator or arbitrator, which would be Marty, in this ongoing process, they agreed to put SAMs in the contract, not any individual, but the organization itself. And that spoke volumes to what we had accomplished. Right now, both Tim and I are involved with separate hospitals concerning mediation issues in the allocation process, and it has worked extremely well. There are times when they say to us, we need Marty to at least step in and give his wisdom, which is not a problem, but Tim and I have been handling that, and we've been getting a very, very positive response. And the most important thing is we were able to avoid a devastating strike. One could imagine what would happen if at least 10,000 nurses were on strike in New York. The dispute was resolved, and it was accomplished in a relatively short period of time. My other, what I thought was an interesting exposure, is when Claire Rose was on strike with local 812 of the Teamsters. Claire Rose is a large beer distributor on Long Island. I won't bore you with the issues of the strike and how it was resolved, but after the strike was resolved, there were questions of alleged misconduct by employees during the strike, and at least 12 employees were discharged. The parties agreed to first mediate those individual cases, and if that was not successful, they would proceed to arbitration on each one of them individually. And because I had the opportunity to participate in the mediation over days and evenings, and my schedule was obviously more flexible than Marty's, the parties easily agreed to mediate those cases before me. We resolved all of them, and I recall there were at least a dozen. And in this instance, the team approach allowed me, as a relatively recent mediator, to gain experience and acceptability, which allowed the parties to use another system which got the matters resolved quickly. So, in short, this system, I believe, is a tremendous valuable tool when you're dealing with multiple parties, multiple issues, multiple law firms. And in today's day and age, when an answer isn't expected within a week, it's not expected within a day, it's expected within an hour. And Julie and I, mostly Julie, have spent many a night on a case, and she'll speak about it in more detail, in which we had to respond to very difficult motions overnight. So now I will turn it over to Julie.
Thank you, Barry. Good afternoon, everyone. Thank you for joining us today. As Marty indicated, I work as a neutral and handle labor and employment arbitrations and mediations. I worked as a litigator for many years before focusing on labor and employment cases for a period that spanned 20 years. And in 2015, I left my firm to start a practice as a neutral, which I continue to this day. In 2017, Marty asked me to join with him and Barry. And since that time, I've worked collaboratively with them and now also with my esteemed colleague, Tim Taylor. So we're here today to review how a practice works with multiple neutrals. And I'd like to talk about how that practice works for employment arbitration cases. As Marty mentioned, this approach is not appropriate for every case. For a simple disciplinary case or a contract labor dispute, this approach would not be necessary. We're talking about large, complex employment cases, high-profile cases, cases involving extremely large dollar amounts, cases with multiple lawyers on each side, sometimes multiple firms representing an array of parties. Indeed, there are cases where these are the cases where the parties themselves wouldn't even contemplate trying the case with a single attorney. And there may be only 2 to 3 cases a year that would warrant this approach. But these are cases where they're beyond the capacity of one single person. Importantly, I want to reiterate now, and I will throughout my discussion, that the initially selected arbitrator, in our case, Marty, makes the final decision. But the other arbitrators can consult and provide advice and bring different expertise to the team. You might be wondering whether there are ethical rules we as arbitrators must be concerned with, and the answer is yes. The Code of Professional Responsibility requires that each arbitrator make his or her own determinations, and they may not delegate any arbitral decision without the consent of the parties. The important thing there is transparency. Marty obtains parties' consent in the cases. Indeed, oftentimes he advises parties he can only become involved if his team can as well. And importantly, all decisions are ultimately approved by the selected arbitrator. So how does this work in practice? From a logistical standpoint, all the arbitrators sit at the hearings. The selected arbitrator sits at the head of the table. Other arbitrators can be at his side. All email and correspondence is sent by the parties to all the arbitrators on the case. The assisting arbitrators contribute where and when they can and share various writing tasks. There's consultation among arbitrators on phone conferences, in office meetings, and now, we do this very easily on Zoom routinely. To illustrate how it works, I'm going to discuss a recent case that Marty and Barry and I collaborated on. It was a discrimination case involving a global financial services firm and one of its female directors. It was a multi-issue, multi-party case. The claimant had alleged that the firm paid its female employees less than comparable males for similar work, and subjected women to disparate terms and conditions of employment. It was very complicated legally. There were claims under the Equal Pay Act, under the labor law in New York. There were gender discrimination claims under the state human rights law and the city human rights law. There were hostile work environment claims, retaliation claims under state and city laws, and there were individual claims against certain individual employees and senior managers for aiding and abetting the alleged discrimination. The claimant was represented by 3 attorneys from a plaintiff's firm. The respondent was represented by 5 different attorneys from 2 separate law firms. 1 individual defendant retained his own counsel. So it was a complicated case. We had a variety of motions that were addressed by our team, and I'll describe some of them to explain and detail how we respond and how we address the issues in an employment arbitration. At the outset of that case, there were motions on confidentiality and disclosure. There was a motion for a protective order on documents and materials to be produced in the case, which we addressed immediately. And then those issues were raised later in the proceeding regarding claims that a party's conduct violated that protective order. We handled motions for review of sensitive information in camera before production to the other side was required. This is also an example of how a motion of the type that SAMs can turn around in a matter of hours or overnight instead of delaying the proceedings for a week or more. We had a motion for a protective order to preclude deposition testimony of witnesses based on relevance. We had more narrowly tailored motions to limit deposition testimony based on specific issues of privilege. The parties served several motions to quash subpoenas to third parties, document requests to third parties. Again, this was motion practice that we as a team could resolve expeditiously without any delay in the case. As discovery progressed in the case, we were asked to review motions to compel the production of evidence regarding, failing to produce adequate discovery. There were also motions for sanctions against parties and counsel during the course of the proceeding, including requests for adverse inferences on factual contentions in the case. We saw multiple motions to amend the statement of claim to add new acts of retaliation. As many of you know, when you have a situation where a complaining employee is still employed at the employer, there are very frequently ongoing allegations of ongoing retaliation. These were all issues, and the complainant made a number of motions to amend her statement. These were all issues that we were able to resolve and make rulings upon within a very short period of time. Once discovery concluded in the case, each party separately moved for summary judgment, necessitating a lengthy summary judgment opinion on each of the claims asserted in the case, which I mentioned were numerous. But using the team approach, we were able to address these motions in a timely fashion and allow the parties to then tailor their hearing evidence to the remaining issues in the case, which made for a more efficient hearing. As the parties geared up for the hearing, we saw letter motions requesting rulings on the requisite showing required for particular claims, and the relationship of an additional pending litigation between the parties in state court. Here, one party had sued another in state court during the pendency of the arbitration, alleging defamation and other claims. There was a motion made to amend the statement of claim to add an additional retaliation claim based on the filing of that separate state lawsuit. The employee moved for rulings that, regarding whether she had to prove that separate lawsuit was baseless in order to prevail on retaliation. And again, using the team approach, we were able to respond to these new developments in the arbitration without any delay in the scheduled hearing. No hearing date, to my knowledge, no hearing date was adjourned on the basis of our needing to make a ruling on any pre-hearing issue or motion. Once the testimony began, we faced motions to recall witnesses who had completed their testimony based on newly discovered evidence, and a motion to submit evidence by affidavit in lieu of testimony where there was a situation where we had multiple witnesses whose testimony would have been cumulative. And then upon submission of the employee's direct case, we were asked to rule on one party's motion for a directed verdict on specific claims in the case before the presentation of the employer's case. and we issued a written ruling on that motion, again, within a very short period of time. So all in all, the hearing was conducted, it was 12 days over a period of approximately 6 months. There were 33 witnesses testified, hundreds of exhibits were introduced by each side. I think we racked up 3,000, there were 3,000 pages of transcript. This was a massively complex employment arbitration. But by using the team approach that SAMS has developed, we were able to collaborate on motions, make expedited rulings, identify issues that needed to be decided and when. We were able to share drafting tasks on various motions and assist Marty with laying out issues, drafting background facts and the parties' contentions in summary judgment opinions, and draft awards, which maintained efficient timelines for decisions and the award, which were consistent with the goals of arbitration being a more cost-effective and efficient process. And again, what I've outlined, what happened in this one case to highlight the complexities of modern employment arbitration. As a team, we've handled a number of cases like this. Some have been discrimination cases like the one I've just described, but others have involved complicated wage and hour issues and other matters. And many have involved multiple parties and parties located across the country. So in thinking about this, I'm sure, one of the questions is, why is the team approach better in these complicated cases? And I would advocate that we make better decisions. We've brought different experiences and expertise to our collaboration. We've changed each other's minds on issues in certain instances. In these cases, there always are natural points in the case where we can caucus and review. I think our system allows for a discussion among arbitrators on complicated issues, so that the decisions that are made are better ones, and they're more thorough than if they had been done in a silo. We try to bring our different backgrounds and expertise to bear on issues to achieve better results. Our discussion on credibility issues often illuminates key issues in the case. And again, the ultimate decision always remains with the arbitrator selected, but the others can raise important issues for consideration, and they are addressed. And moreover, the parties have a comfort knowing that on these large cases, there's backup. There are people that they can go to if they need a decision or a ruling on a procedural issue in an expedited manner. They also have the confidence to know that no facts are going to be missed or overlooked. All case law is going to be read and considered, and they don't have to wait months and months for a decision. Lastly, and importantly for me, and the reason I've so enjoyed my collaboration with the team here, is that as individual arbitrators, I think we've all become better at our own practices. Newer arbitrators are typically not exposed to these complex cases and issues in these types of arbitrations. And being part of this team gives newer arbitrators exposures to issues and exposure to cases that they might not see for several years out in their career. Arbitrators have always had a certain level of collegiality with one another, and I certainly do, even with arbitrators outside this group. But the collaboration here is not ad hoc. It's planned, and it's something that we can rely on as a team. And, certainly there are instances where I'm very busy in my own practice and writing my own awards, and I have to scramble to find time in a book schedule to assist on one of our group cases, and that does happen. And sometimes, I have to work either before one of my own hearings or after one of my labor arbitrations adjourns to look at one of these cases that we work on collaboratively. But I do it because it is making me a better neutral. And I also know that we have a team here, and that if one of us is jammed, I know that Barry or Tim can jump in to assist as well. We've developed a level of collegiality and trust, and we know that we can rely on each other and each other's work. Lastly, I would just make the contention that this arrangement helps develop a better group of neutrals for the parties. And, I think the three of us would agree we've become better arbitrators and mediators by virtue of our association with SAMS. So thank you. At this point, I'd like to turn things over to my colleague and friend, Tim Taylor. Tim's an excellent neutral who I greatly admire and respect, and I'll let him take over at this time. Thanks, Tim.
Well, thank you, Julie, and those are very nice words. And I smile a lot when I'm on the screen with these people because I love them. They're just wonderful human beings. And Katrina, thank you for inviting me. Congratulations to the Hub. And Ellen is usually with us, but I know she's a little under the weather today. And if she's watching, I want to say hello to Ellen or Priscilla as well. So I'm trying to think back to the first time I met Marty Scheinman. I think it was in the early 90s. It might have been 1994 in a small town in the Catskills. I was handling a 3020A, and the opposing counsel was this wonderful lawyer named Rochelle Auslander. And I was waiting, the hearing started at 10, and I'd heard so much about Marty. And I worked for New York State United Teachers at the time, and Marty was a big arbitrator that handled internal disputes that the union would have. And he also handled some other arbitrations for us. And I remember sitting there, and I was expecting him, and I was going to, his reputation was that he was really fast. He got to the point. He didn't play around. He did quick analysis, and he resolved the cases. And I was convinced that I was going to slow this man down, that I was going to make him listen to my evidence. I was going to make him sit in that chair and stay from 10 o'clock in the morning till 4 o'clock in the afternoon. And gosh, he was going to listen to these witnesses I had lined up, right? So Marty gets there, he blows in. It's in the summer. And he said he's going up to Saratoga because he's got a horse either that day or the next day. And the horse was this horse. I'll never forget it. It was something with like Juju Gin. And he was going to go up there, and he called me and Rochelle outside, and he says to me, "What's your case about?" And I said, "Okay, I'm going to give him a little bit of my opening statement." And he goes to Rochelle, "What's your case about?" And he goes, "Okay, this is what you're going to do. You go in there, talk to your guy. If he needs me to talk to him, I'll talk to him. This is what you're going to do. 1, 2, 3. I'm like, I got all these witnesses. He said, "This is what you're going to do." So I go in and I talk to my guy. My guy's ecstatic. That's a resolution? I go, yeah, but don't you want? No, that's great. I'll take it. I was home before noon. And I'm sitting there going, how did he do that? So that was Marty Scheinman. Fast forward. The next time I actually had an extended conversation with Marty was at the track in Saratoga, right? You see the connection? And it was in late August of 2018. And Barry had set this up because Barry and I had gotten to know each other from our work down at 100 Gold Street. And Barry was just great. I had lunch with Barry. Barry's very engaging. He talked about guitars and Basil Patterson and his upbringing and all these. He's just charming, right? So he says, "Marty would like to meet you." I'm like, what the hell? What did I do? So Marty would like to meet you. He wants you to come up to Saratoga. There'll be tickets for you at the booth. I went up to the booth. They took my car. I never had valet parking at the track before. They gave me these tickets, and they started to walk me in. I'm saying, "Oh, this is going to be great." I get about, and they keep getting closer and closer to the track itself. I'm like, where's these seats? Marty's box is right at the finish line on the rail. And I'm like going, this is nuts. So I talked to Marty, and I quickly find out that he doesn't drink, and he quickly finds out that I don't gamble. So this is like the worst idea ever to meet at the track. But my failure to manage my own expectations turned out to be one of the most important and pivotal moments in my career. Because what Marty wanted to talk to me about was a collaborative, innovative, novel idea about working in a team to resolve disputes. And he said it wasn't a merger. I didn't have to leave my practice. It was more of a startup. It was a new venture that he wanted to take the lead on because he had, and this is it, he had the number of cases, the volume of cases, and what he really wanted to do, and this was his word, not mine, he wanted to develop bandwidth. He wanted to develop the capacity to deal with a high volume of cases in an extremely intimate way. What I mean is that he would give more attention to the parties, not less, by adding more qualified expert neutrals to his team. Imagine that, right? He figured out a way, and I'm convinced, everybody knows Marty knows he's different. He's not like everybody else. I think he's probably a genius because if you ever, and he says he's not, but I can tell you this, if you have ever found a faster thinker, you let me know, right? He thinks so fast that I believe sometimes he races to catch up with his own thoughts because he's that far ahead of his own self. So he's talking about these things. He's talking about how to resolve complex disputes, and you've heard everybody talk about that. He's talked about working together, collaborative, bandwidth, to handle the matters. And these certainly are important. But his genius was that he figured out how to adapt to a situation that hadn't occurred yet. And it reminded me of one of my favorite books when I was a professor was Who Moved My Cheese? Right? And I think all of us have read that at some point. And it talks about he who adapts late need not adapt at all. Right? He who adapts late need not adapt at all. You have to spot trends before they actually become trends. And you have to move to a different place so that you are ahead of the curve, not behind it. And I think that's what he was talking about that day. Also, when he was at the track, he asked me, as Marty always said, so what do you got going on? What are you doing? I tried to slow down. I said, Marty, hold on a second. I'm teaching, I'm arbitrating, I got courses here, I'm doing work at SUNY, I'm on the government law board at Albany Law. And he said, stop it. He said, you need to focus. He said, at your point in your career, you need to focus on your arbitration and mediation skills, and you need to focus all your energy in developing that practice. And I listened, and I took that advice, and I retired from teaching, and I decided that I would go all in on arbitration and mediation. And it was, I think, one of the best decisions I've ever made, like Barry said, to eliminate all these other things in my life that I really thought were important, and they had served their purpose. But it was time to embrace the change that Marty was offering in terms of this startup. I did not have to give up my practice. I had been practicing public sector labor law for almost 30 years. I had built an intimate and expertise in that area. I had done everything imaginable, from collective bargaining to arguing at the appellate level and beyond, these high-level cases involving unions and arbitration. And I was fully confident in doing that type of work. I had arbitrated at that point as an advocate well over 400, 500 cases. At that point, in my own practice, I was ready to submit my application to the National Academy. But I knew I still needed to grow in other areas. At that point, the offer to work with someone like Marty Scheinman, and Marty thinks you're elevated. It's not. This is just the way it is in our little industry. That Marty is different because he's probably the best arbitrator I've ever worked with. Barry said it. Everybody, I honestly can believe that. I've worked with a lot of different arbitrators. I worked, like I said, 400, 500 cases as an advocate. Marty's probably arbitrated, I don't know, rough estimate, 40,000 cases, written over 27,000 different awards. It would take me a whole nother lifetime to get that amount of knowledge and skill on my own. Now, it's said that you cannot buy experience, but I believe that you can rent it. And so whenever I'm with Marty, I get to rent all that experience, right? For the time that he's done more than I've done. And I'm not ashamed to say that. But I have a different lived experience as a African American from the Deep South who went to Cornell and lived with a Jewish family in the Bronx as a young adult. I have a different viewpoint of the world that he does not have. Doesn't mean it's better, doesn't mean it works. It just means that it's different, right? And so I can add things. I've done a lot of litigation in my life. I've taught, whether it be civil procedure or whether it be constitutional law or whether it be evidence or whether it be administrative law. I've done those things. I can bring that to the table. So you have this wonderful mixture of people. And I can remember my first case at Sam's. It was very complex. It was beyond anything that I'd handle even as a litigator. And I'd handled big cases as a litigator. I sold the Dewey Decimal System when I was 26 years old. You know, I'd done big transactions, multi-million. I'd worked with big partners and big law firms in New York City. I'd done all that. But this was different. This was multi-jurisdiction, multiple states, state law, federal law, franchises, different languages, different people, states attorney generals involved, local state lawyers involved, lawyers from the West Coast, different time zone, judges, different courts involved. And all of this had to be managed because if it wasn't, it was going to end up exploding and end up being a very costly and time-consuming ordeal. And this is what I walked into. It was resolved. It was resolved in a very careful, thoughtful, processed way. Every detail was analyzed. Every possible argument was discussed. Every possible jurisdictional question was addressed. We had judges on the phone. We had rooms at 322 Main Street in Port Washington. All the rooms were filled with different teams of lawyers, and each team of lawyer could have an arbitrator mediator go in there and start to collect and analyze all this data. That was the genius of it all, that all this work could be done at that time, at that moment, with everybody present. Needless to say, the case was resolved, and I believe Marty made the news and the headlines because this was the gravitas of this case. So that was my first introduction to how this could work. And I began to think more and more about it. And so, Marty and Barry would invite me down for more of these employment mediations. And I started to develop a real, love for it, because what would happen is I would get the employment mediation statements maybe the night before. Believe it or not, lawyers still do that. They send things the day of, with the expectation that all this material would be reviewed and analyzed, digested, cataloged, bracketed, researched by the next morning, 9 o'clock. Right? That's what I mean by the speed that's necessary to do this, because Marty has an idea. His idea is the party's day with us is their best day. It's their best day. And I never forgot that. It's a dedication to believing that when the parties and the advocates walk through that door, that they're going to leave at some point being completely satisfied with not only the process, but the result as well. And that takes a high level of awareness. And I just think about some of the traits that's necessary, really, when you receive an employment mediation statement from both parties, and they come with exhibits, they sometimes come with videos, they come with sometimes depositions, they come with all this supplemental material. And I tell you, they come late in the day and they have to be analyzed before the next morning. What do you need to do that? Well, you have to be a progressive thinker. Sometimes you have to think outside the box. You have to be observant, right? You have to, as we say in sports, you have to play 360. You have to play 360. You have to scan the whole field all at once, right? You have to be solutions oriented. You have to keep your eye on the ball, which means at the end of the day, you need to get a term sheet, and you need to get this term sheet signed. And no matter how long it takes, you've got to get the work done, and you've got to keep pressing, and you've got to keep going back and forth, bracketing ideas, bracketing arguments, bracketing facts. You have to be reflective. You always have to think about what you've done, discuss it, move on, go back to it. Was it right? Was it true? You have to be highly intelligent, and you have to be intentional and self-aware of how you yourself and how you are influencing the advocates and the parties, and how your demeanor, because as you know, we joke around, you can predict everything but emotion. You can do all the planning you want, but however you think it's going to be, it's not going to be that way because of the X factor. And the X factor is always the emotional component to employment cases, particularly whether they be employment discrimination cases or they be sexual harassment cases. They're highly emotional, and you have to manage the emotion that the parties have in the room, the complainant has in the room, and you have to manage your own emotion. And so I think those are some of the really wonderful qualities that you need to really do this work. I think about my relationship with Barry and Julie. Fast forward from that day at the track with Marty in 2018 and move forward to, it was in the fall of 2019 before, the pandemic. And we had a strategic meeting at a restaurant in Midtown, and we all met there. And I think Julie was coming from a hearing, and Barry was coming from a hearing, and I was coming from some bar event or a hearing, and we met, and we just sat together, and we just talked about the world of arbitration and the kind of cases we were handling, and just discussing, strategizing SAMs, and it was new and it was exciting. And we were planning to travel and go to locations and really explore and expand our practice. And I tell you, it was so memorable and so nice because of all the folk today have said, being an arbitrator and being a neutral can be solitary. I wouldn't say it's lonely because I've always been comforted with my own thoughts. So even when I'm alone, I'm not lonely because I'm always thinking in my head. But it is solitary, which means you have a tendency to silo. And but being able to spend time in a restaurant with colleagues again, sharing that discussion and sharing the I got to slog here and I got to slog here and I got to get this decision out tomorrow and I need, I'm really pressed for time, and just being able to relate to another human being on that level was wonderful. I think about some of the things I've learned from watching and observing Barry Pete. I can tell you he's really probably one of the best time managers I've seen, and his ability to balance his work with his loves, like he loves his wife, but he always finds time to be planning things with her and going places with her. And he has this wonderful social life. And I'm like, I barely have time to get my work done. And he's working I get it in the office sometimes at 8:00 and Barry's already there. He's already logged in on his computer, but he finds time to practice his guitar. I don't know how he does it. Time management, not wasting time, and finding the balance through all that. To spend time with your family is important. To spend time with your hobbies and your passions is important. While also being the consummate, professional, never late, never in a bad mood, and always willing to take the time to help you. With Julie, she's so thoughtful. She's so precise, she's careful, and she's a wonderful writer. So much so that I invited her to join the Labor and Employment Law Journal as an editor, And of course, she couldn't say no. I mean, of course, she's not going to say no to me. So she's joined that, and I'm so looking forward to growing even closer. Now, Marty's different. Marty's probably more productive than anybody I know. He's always in motion, but yet he's focused. That is a real skill. I've tried to adopt a lot of that into my own practice. Remember, we didn't merge practices. This was a kind of almost like a startup. But some of the things you can learn from just watching a Marty Scheinman and being in a room with him and being close to him is the way that he doesn't waste time. And what I mean by that, he's there early, he's there late. I don't know where he gets the energy from. I've actually seen him leave the office at 2:00 in the morning, and he beats me back to the office at 7:00 in the morning the next day. And I'm figuring out, how does he do it? When does he sleep? Does he ever get tired? It's about being productive. It's about managing your life in a way that it's seamless. And I've thought of this concept about Marty. It's singularity of effort. All his oars pull in the same direction. Everything works together, right? Everything works together to achieve a goal. And so I think that's one of the very big takeaways I have from doing this work with this wonderful team. So what are some of the other takeaways I have about the way that we manage cases in particular? I'll get back to employment mediation, but I think you need context for relationships and stories about how things actually work. The takeaways is we're very efficient at what we do. We're very efficient. And when they tell you that if we got a case on Thursday night, we could analyze it, figure it out, work together, be detail oriented, get all the facts right, get all the law fact, and get you a result by Friday afternoon. I don't know of anybody else who can do that. I just don't. I don't know anybody else who has the bandwidth to do that, but we do. We're also a much less formal alternative to litigation. People come to us to avoid litigation, particularly in employment mediation cases. They do not want to go to litigation. Litigation is costly. It's not speedy. It's not economical. And there's no guarantee of you getting a just result. We behave ethically and with integrity in everything that we do. We're transparent, and we don't hide the fact that we're working together. Everything is out in the open, and I believe that we give the very best in service. And I think every day we ask ourselves as a team, how can we be better? How can we give the parties and the advocates who use ADR a better experience? And I know it's serious work because we talk about it. We talk about the profession itself, how to make the profession better. And one of the ways that I know Marty and I have talked about it, and I know Barry's committed to this, as is Julie, is that it's a wonderful opportunity for a newer arbitrator, maybe a newer diverse arbitrator, to come into a fully developed practice and learn the very best practices, the very best way to go about this business. What I personally gained is, of course, I get exposures to matters that I otherwise would not. This year alone, I've handled maybe 15 employment mediations, maybe more. I lose track. Where else would someone from the public sector, have been given that opportunity to deal with high-level law firms and high-level advocates and gain that measure of experience in such a short period of time? I've also handled countless wage and hour complex pieces of litigation and mediation. Where else, from someone who has a public sector background, those cases would have taken me a much longer boarding period of time before I would have been able to handle those cases with the amount of confidence that I now have in handling those cases. So those are some of the things. Now, how do you really handle a lot of these complex cases from, a real nuts and bolts way? The first thing you have to do when you get a employment mediation statement is you have to become an expert. You have to become an expert right away. You have to know all the facts in the case. You have to know all the nuances of the law. You have to apply current and real world trends to the legal matter that you are mediating. You have to stay current. I'm talking about same day current. Were there any changes in the law? Were there any currents in trends? Is there something percolating up through the judicial system that makes this case ripe for settlement today? And you must be confident that the mediation that they're having will get them the most money and save them the most money at the same time. And I think that's really something that I'll always keep in mind. Another thing you have to be in becoming expert is you have to maintain confidentiality, because confidentiality is very often one of the most important considerations that the parties have in mediation, and not the type of confidentiality that violates the law or is no longer acceptable, but the kind that looks to the individual complaining and thinks about some of the safeguards that they want. It has to come from them. It has to be a request that they're making, not to divulge. The second thing I would say is working as a team on employment mediation cases is the communication skills. You have to communicate and be responsive and always keep the parties informed with anticipating what information will the parties want. What information will the parties need? You have to do this without making assumptions. You have to kind of know in advance, by doing your homework, what the parties are going to need. You have to respond promptly, immediately, not later in the day, immediately. And if you have the necessity, you have to schedule meetings with people right away, not a week later. I'm talking about, the most I've seen is maybe a couple of days. And you have to stay focused on the parties matter. Over time, this is my next point, over time, you get to know the parties, you get to know their business, you get to know their culture. And the more you know about the parties, the better you can serve and meet the parties' needs. And that all goes into what I consider competence, and being competent to handle these matters for these people. These are serious individuals who are dealing with very, very serious cases. I don't know how much time. It's already 5:18, Marty. I don't know if you want to turn this back over?
Yeah, well, I think yes. I guess a couple of things. Do you want to answer some questions first, Katrina? Is that where you think we should go? And then I can pose some ideas and questions.
Yeah, I think maybe we'll take just a couple of questions and make sure that we have enough time where then you can kind of float some of the ideas that you talked about in your introduction, Marty.
Go ahead.
So a couple of questions that came in from our audience so far. How can one learn more about, for instance, the labor dispute between the hospitals and the nurses union?
Barry, you want to respond to that?
How can they learn more about it? Well, number one, there are probably newspaper articles that have been written about it during the time, and certainly after it was completed, because of the new issues and the complex issue of ratios and allocations. I also believe you could probably go online, the Neisner website, and you could learn about those issues, and if need be, get a copy of the final documents. If anyone has a specific question that they'd like to know about in terms of a particular issue, you can certainly reach me at barry.peak@scheinmanneutrals.com, and I'd be happy to either speak to you or, respond to your email. But that's the general place where you can look for it.
Katrina?
Yep. There was actually a follow-up question to that and asking about whether SAMS has ever had to intervene in a labor dispute with hotel unions.
Well, each of us has. We each have roles with that. Those tend to be, as Julie laid out earlier, in a traditional labor management dispute. It doesn't usually require the kind of expansive teamwork that you would want in that. But individual members of SAMS, Julie or Tim or Barry or myself, would do that. Well, let me just jump in some of the thoughts that people ask, well, how do you get parties to agree to this? How do you explain to them why it's in their interest to do so? And so let me just pick up a little bit about that. A lot of arbitrators, some of you in the audience will know this, have relationships where they are the permanent arbitrator. For example, I'm the permanent arbitrator in between the nursing homes and the healthcare union and the hospitals and the healthcare union. I'm the permanent arbitrator in a lot of other settings. And the parties, transit and the like, parties will say, well, we'd like you to take on some responsibility. And what you do is you say, which is the reality of it. I couldn't do it myself. I don't think I would be as both on a time basis, on a competency basis, on the word of the day, the bandwidth purpose. Think of what Julie talked about, what was involved with that single case. So I'm telling you, if you want me to do this, I have a team of people who work together. As you can see from what you heard, these are not subordinates, these are colleagues, and that we can do this well. And one of the things that's interesting is this year I was asked to be the arbitrator with Major League Baseball and the Major League Players Association. You're all reading about, the issues that are arising with spin rates and all those other things, which may or may not come to me, but some of them are going to. Certainly you saw there was a grievance, some of you read, like sports, about that the Players Association has filed a grievance for $550 million about the length of the season. When I took the assignment, I said, there's no way that I would be able to handle this alone. And in fact, as Julie made, and this is in a traditional labor management setting, I said to them up front, I'm going to invite my colleagues on the days that they're available to come and sit in, because there's no chance the timeline you have described that I could turn around the awards. And the first award, which was, many, many, many pages, we got it out in 2 weeks, which there's no chance in the world I could have, and the parties needed it that quickly. And just to give you a context of this, you say, well, isn't that awkward? It's not awkward at all, because the parties are sitting there. When these cases are tried, we all know about Zoom now. There's not enough room on the page of Zoom for all the lawyers and all the labor relations professionals that represent the league and the like. And we haven't even had the cases yet that involve the individual teams. And so, that's my job. I'm the arbitrator. As Julie said, the assigned arbitrator is the one, but everybody understood, because it's completely disclosed, as Tim has spoken about it, that this assignment is beyond the capacity of at least this arbitrator. Maybe others have more capacity than I have, but you can't do it. And interestingly enough, this year I was asked to take over a big role in the hospitals and with the healthcare union, which is called the CIPIC role. It's the big role with the hospital systems, all of the hospital systems, covering hundreds of thousands of workers. Sure enough, when I took the role, I said, look, there's no chance that we can do this myself. I'd like you to be able to agree that on a given day, I will bring one of my colleagues with me, and one of my colleagues will assist and will work with it, and sometimes take the full lead and like. Tim didn't get a chance to talk about it now, but right now, the follow-up with this staffing thing, I have not been in a single one of these mediations. They're going on simultaneously. The team is doing it. They give me some information. Once in a while, as Barry pointed out, they'd say, I think you need to come in and maybe raise your voice a bit. But mostly we got it, and we can handle this. We don't need to be there. And frankly, I don't even know what's going on. In these big cases that Julie talked about, the parties agree that if this issue comes up, they will contact Julie. They wouldn't contact me. There's no need to contact me. She knows more about it. She's better at it. And that's why disclosure, transparency is what I think is the new way to do it. Now, one of the questions you ask yourself, if I can, about questions, and I haven't even told my colleagues these questions, you wonder, is this really the right model for everyone? I mean, there's law firms, right? Law firms have traditionally spoken about how they have, or human resources departments, that they have people who have collegiality, and there's a fertile ground for people to think about it. But, arbitration, has usually been, the theory is you're on your own, you announce, or you're a mediator, and you sink or swim. Hopefully you'll make it. Katrina spent a lot of her professional life trying to figure out how to launch the careers of people who would like to be neutrals. And just as an aside, if I may, people always say to me, well, you spend so much of your time and resources trying to educate the next generation of neutrals. Why? Aren't they competitors? Aren't they people who are going to take work from you? And I said, I have never been concerned about that, even when I didn't have that much work. The only thing that ever concerned me, which is one of the theories behind the Institute, one of the theories behind SAMS, is that the only thing that's bad, or anything that's bad for my profession, is bad neutrals. People who are not trained, people who are not doing it. It's hard of the metaphor, but I always say, when you're in New York City and you're going to the theater at night, everybody goes to the theater district to one of the restaurants. All you should be concerned about is that all the restaurants are good. Because one night you might want Italian food, and the next night you might want Korean food. But as long as they're all good, you're going to make plans to go to that area. If one of those restaurants is not very good, or they have a bad experience, it dissuades people to doing it. That's what I think about arbitration and mediation. That as long as you have a competent, wonderful person, I'm not worried about it being one of my colleagues. I'm not worried if one of my colleagues eclipses me. Good, God bless them. But I am worried about people being served by people who don't know what they're doing. And that's one of the things. And everybody's talked about what I've taught them. They've taught me immense amounts. And because of that collegiality, you hear about experiences you wouldn't know. Obviously, Julie has different life experiences than I do. So does Tim. Barry, although we're similar in terms of age and background and religion, he has things that I never had. He perceives himself as dramatically younger than me, so he tries to persuade me about that. It's actually only 2 months, but he thinks it's 20 years. So anyway, one of the things I wonder is it really a good model, or is it too much of a crux, as opposed to the traditional model of arbitrators that we tell them all the time, don't we, Katrina? We can help you. We can help you with the skills, but basically you're on your own. It's a sink and swim. So, I mean, candidly, has it helped your careers, Julie, or has it hindered it? And is this notion of having, a backup, is it really a good thing for a progressive practice, or are we better off not following that? And nobody knew these questions, so I promise you, I don't know what they're going to say. Julie, what do you think?
Without question, it's helped my practice. It's exposed me to situations that, again, I would not have seen as an arbitrator for years out, and it has made me more competent and more well-rounded. I've been exposed to parties that I would not have met, and issues and situations, and just given me a breadth to my practice that I never would have had without my affiliation with SAMS. So for me, it's been invaluable. And I think, in terms of, whether this is a model that others can replicate, I mean, again, I think it works for the parties. I think it's beneficial for them. So
just as a follow-up of that, something to think about. Barry, I'd ask you this, actually, and hopefully people watching are wondering about this. I mean, is this sustainable when the founder is gone? And is it sustainable? I mean, will they be able to educate the next generation? When I'm no longer doing this, and maybe some of you are no longer doing it, will a practice of arbitration and mediation be able to survive so that it will help parties who need competent neutrals? Barry?
Well, there's no question that it will survive those people who move on. If you are not involved, I'm sure that the practice will be different because you are the one person that people think about in terms of disputes. But I have to say, for me, number one, I would not have done it if I had to be alone. I'm not that kind of person who likes to do things by themselves. I am much better. As a lawyer, I was much better. And as an arbitrator mediator, I am much better in a collaborative setting. Kind of keeps me up from walking into the quicksand, as sometimes I see it. So I never would have changed, but for the fact that I was able to be with you. I also had a more difficult question that my colleagues didn't have when joining SAMS, because you and I had a friendship. And that to me was worth more than anything that I could have gained. And yet, just speaking for myself, the friendship has never been better.
Do you think that this model, Tim, in the West Coast, I mean, obviously because of Zoom, our practice has changed and we can go around the world, but frankly, at some point, hopefully we're not going to be doing everything on Zoom. Maybe the rest of the world won't be. I will, but because I don't like to travel. But the question I have is can this exist in other places? Is it a place where we can educate the next generation of neutrals to work together? And is this sustainable in that parties will say to themselves, this is really the kind of neutral practice I want to exist, because that's who we're going to call upon? What do you think, Tim?
I think it is the perfect model going forward. I do a lot of work in the areas of newer neutrals, whether it's with the State Bar or the National Academy, and I think it's a wonderful addition to someone's practice. Imagine someone just starting their practice. They don't, they may have context, but they don't have enough. They're busy, but they're not busy enough, and they still need to learn about how to be an arbitrator. The best way that they could do that is if they were some local, but you'd have to be in a large enough area, I believe, to have it be sustainable. But what you would have to do, I believe, is to have this a team like SAMS that you can work with collaboratively, but also have a spinoff business that you develop on your own. And so those two would always work hand in hand. As you're developing your skills, you have your individual identity, because that's important to focus well. People need to know that you can do these things alone, but you can also do these things as a team. What it does is a lot of times we struggle with newer arbitrators, particularly ones that aren't traditionally in this field. And I think that's one of the ways that we can address this ongoing need now that parties have for diverse neutrals, right? Every union that I've been able to work with, and I'm blessed to work with most of them, and I'm very thankful for that opportunity, they're not looking for something different. They're looking for diverse neutrals, whether they be women, whether they be Black, whether they be brown, whether they be Asian, whatever they are, whether they be LGBTQ, whatever the community is, they want to see that reflected in rosters. And I think one of the best ways to instill confidence in these newer arbitrators is to have them align themselves with a team such as ours. And I think that is a path forward. Do I think it's the only way forward? No. But when you're thinking outside of the box, when you're trying to be innovative, it's oftentimes best to take an all of the above approach. And I think this is definitely one of those approaches.
So, Katrina, segueing to some of the questions and the like, one point people ask all the time, well, is this transferable to other things? And my answer is, it seems like it. Someone asks, are arbitrators and mediators involved in justice work? Sure, all the time. Early in my career, even when I was in Ithaca, I would travel. There was something called arbitration as an alternative that would do, this is when I was very young, that where we would deal with the court system out of the city of Rochester and kinds of issues that would come up in community. I mean, I mediated disputes early in my career with fights between residents of public housing who were Hispanic and residents of public housing who were Hasidic. Other kinds of justice issues we have, I was just talking about this today, ironically, it was about claims by the referees who were referees of color and women at the United States Tennis Association and the International Tennis Foundation, which is what runs the Grand Slam. And no woman or person of color had literally in any Grand Slam ever been a referee in the semifinals or the finals, whatever. You don't, now it would shock you, but if you look at when you watch the US Open, you'll see, I guarantee, a woman or a person of color in the men's tournament. It didn't happen. These are issues that were done. Now, in terms of what's going on in community, arbitrators have been often called. The person who actually, one of the people who preceded me in some of the roles, George Nicolau, who just passed away, ran a center that was entirely designed while he was also a labor and management arbitrator. He ran a center early in his life about community dispute resolution in terms of issues of race, desegregation. I can tell you the whole thing. So yes, they have. Someone asked, what kind of sanctions do arbitrators impose? Actually, this is an interesting question for a team. When you're confronted with that kind of question, I remember recently we talking to each other about whether or not there should be an adverse imprints on the case that Julie talked about. We also have experiences where parties say we want them to have to pay for this extra deposition. When they canceled the hearing, they should be the ones that are responsible. Or, frankly, we want you to sanction them in other ways. We want you to sanction them financially and the like. Arbitrators tend to be very hesitant to do that, but as you deal with some of this kind of litigation, occasionally we are brought upon it. It doesn't happen often. But one of the things I think people are wrong about, and the existence of a group like SAMS, where this sort of collective wisdom actually impacts this. That is, parties tend to comply with what arbitrators do. And they particularly comply with arbitrators who they think are wise. And when I will say sometimes in these kind of things, I talk with my colleagues about this. We're all in consensus that this is the right approach. It brings certain kind of gravitas, if you remember, I mentioned that in the opening, but it also assures them and me, it's just not a Caucasian male who's 68 and a half years old that came to this conclusion. It's people with a whole series of experiences and the like about that. Each of our human experiences goes into that. So I think that's right. So you think it is sustainable afterwards, and you think it's enhanced your practice. What's the disadvantages? One for me, the disadvantage could have been that when I have colleagues who are working with me under a banner that has my name in it, by definition, I have to be sure and comfortable that they're doing a great job because it's a reflection on myself. That would be. Now, I'm very fortunate who I have, but that would be a disadvantage for people. And similarly, it would be a disadvantage for people who are in that aura that say, well, it turns out I think Scheinman's a dope. And so therefore, if you're associated with him, why in God's green earth would I ever pick you? That's just real. But what are some of the disadvantages? Because I want people who are thinking about this to think, maybe this is not ideal for me. Maybe I wouldn't want to be in a practice where there's others who I would work together. I just make this point. Julie said it in a sensitive way about, change his mind. What she's talking about is often in a hearing, she kicks me under the table when I'm making a ruling and basically persuading me I might want to rethink that ruling. But part of that is also that you have to have people who are open-minded about this. So I'm not sure this is right for everyone. A lot of arbitrators feel they have to be godlike in order to be able to make such decisions because they are not infallible. They feel the anxiety of making hard decisions. But so I guess I'd ask you, Tim, why don't you start first? What would you see as disadvantages for people who are contemplating having what we call today a progressive team approach to resolving cases or deciding cases?
I think you have to be true to your own self. I think that's really, I don't know if that's a disadvantage, but I can tell you some of the personalities here are very large and they're very confident people. And so if you don't have that for yourself, you're not going to, this is not for you. You have to be able to hold your own, because these are some very big personalities. They're not bashful. They're not shy. They throw elbows and they make themselves heard. So if you're not that outgoing, if you're not, willing to really, hold your own, speak your mind, push your point across, you're going to get run over by a group like this. It's just, I don't think it's going to work for you. If you're a little bit worried about your ego, or that, someone else is getting more than you, or someone's getting a bigger spotlight, this isn't for you. This is where you have to push set your ego aside for the greater good. And the greater good is not only the team, but the principles and the innovation that we're trying to push forward. You have to come second to that. And I don't think everybody has that mindset.
Julie?
I would just kind of jump a little bit on what Tim's just said. I think, this is not a situation, as Marty, you said, this is not like an associate, relationship. So you have to be true to yourself and you have to develop your own style. And while I have learned a lot and taken a lot from this group, I would never walk into a mediation and try to run it like you do, Marty. I have my own style. I have to be true to myself and manage cases the way I feel it's appropriate. So I've learned a lot, but I would certainly never, and I think the parties would know that to be a false situation if I tried to run around and be like a little, mini Barry or Marty or anybody, So I think you have to be somebody that's going to be, strong enough to develop your own persona and your own practice and your own strengths, but to draw things from the group that enhance your practice, but you can't, you can't like fall into someone else's role.
Barry?
Well, I think, I'll echo what Tim said. You have to be able to kind of check your personality and your ego at times, because you don't want to get into a situation where someone says, well, Tim was assigned to this and with Barry and I wasn't, or Barry and Julie are working on this case and I can't. That's also a problem that you have in law schools and law firms. But the other issue is the economics. If you're spending a day collaborating, you're not having that day where you may be getting a case on your own. And you have to, it's a very, interesting situation. And you have to be able to know that there are days where I am here and I am helping, but it's not the same as if I was on my own for the day. So that creates a different issue that has to be dealt with. And some people just want to live their life that they eat what they kill, and they don't like to be collaborative. And that could be a negative for someone who starts out. But I think certainly the positives completely outweigh any negatives. And you also have to be in a practice that can sustain collaboration. Not everyone can. Not everyone has the cases that come to them that may warrant it. And I hope someday I start getting those cases. And it's starting where there are cases that are coming to me that I believe I would go to Julie or Tim and say, in conjunction with Marty, hey, even on my case, let's collaborate, let's work together, because it's big, it's huge. There are multiple parties and multiple issues.
Let me just make a point, if I would. I think if you're going to do this, you have to be willing to press parties to also select these colleagues of yours in situations where you are not able to take that on. I just want to make that point in terms of practice. So each of my colleagues, fortunately, I've been able to help them get on permanent panels that probably was earlier than they might have gotten on it. Doesn't mean eventually they would not have gotten on them. And you can do that. And you have to tell parties, this is what it is. I can't do this, but I think Julie's ideal for that. I think Barry should be on this panel. I think Tim is ready for this, and so forth and so on. And that, of course, builds more of a experience base that when we work together, they have more experiences than they would have had without those things. And all of them have active practices about that. Someone asked, do you use humor in your work? I say, why are you asking? No. So the answer, of course, we use humor in our work. If you mediate, mediation in large, look, what is mediation in large measure? It's persuading people who are pretty smart to change their absolute commitment that they're not going to change their minds. And people say, well, how do you do that? And I always say, well, how many people overpaid for a car or a home that they swore they would never, ever do it? Or a particular shirt or a suit or a blouse or a skirt. And the answer is something made you change your mind. And that's what we do it. Some of the times it's humor. Sometimes it's showing people the folly of what they've held dear. And I've sat in a room with each of my colleagues who will tell a story that maybe I wouldn't have told, an experience I didn't. So humor is very important. Arthur Beck wrote, this horse thing he reminds me that he was with me at some point at Saratoga, as I recall, at Belmont to watch the Secretariat win. All I would say about that, as I recall it, Katrina, he made a lot more money that day than I did, but that was typical of Arthur, who was my room.
I have a story about that. Remember, Marty, when we were at the track, I don't gamble, so I had no idea what you were doing. You and the doctor next to you were doing a pick six. I don't even know what that is, right? But you had picked 5 winners in a row. And I said, I got to go because I was like the Godfather. I know you are a busy man, so I will leave you now. So I had to leave. And I said, Marty, call me and let me know what happened in that last race. And so I think you did call me, but I don't remember. Did you win the pick six that day?
No, I did not. But okay. So that's he likes to bring back sensitive subjects, Katrina. He's trying to hurt my feelings. All right. So I know we don't have much time left. Katrina, you have anything else that you would like to bring forward? It's hard for me to see as I'm talking.
Yeah, no, I think the only other thing really is, do you see this growing? And if so, how would a person actually get a practice like this going? If you're the newer neutral that's needing the experience, or if you're the more established neutral that may want to bring in collaborators?
Let me start with that. First of all, let's do the latter part of the question first. It's not, I'm doing this for over 40 years. I did it when I thought it was time, and I spent an awful lot of time thinking who would be good colleagues. Just like any other partnership, relationship, and the like, if you're someone thinking about that, you not only do you need to be in a position where you have to have the depth of practice to make this work well. You also have to realize, I don't want to talk about money, but you have to talk about that you're going to be giving up some money, or you're going to facilitate some of that, because that's important. We have different financial relationships, the three of us, because of where we were in our careers, where they were in their careers when they came and did it. And we have to work it out. And it's got to be transparent. It's got to be open. And it's got to be alike. One of the things that I mentioned in the opening remarks is there have always been ghostwriters, and there have always been arbitrator assistants. And I can give you countless stories of me arguing with people who had that, because they would not believe it was appropriate to have someone who assisted you who got compensated. And I thought that was just ridiculous. And we spent all these years with the Scheinman Institute wanting people from all socioeconomic backgrounds having the opportunity to make it as an arbitrator. And so one of the things you can help by this way is you're getting tremendous value as the founder, but you're also making sure this person can be able to feed his or her family, that person could not feel that jumping in is going to be so frightening because it's just financially, it's not fair that a profession should be premised on the fact that someone's willing to make a change and jeopardize their family's economic circumstances. This is exactly what we think is wrong. So if you're a founder, or a person who's thinking of doing this, or an arbitrator who thinks that they have enough work, or an arbitrator who's got to be honest with themselves, as I was, I'm not doing this great when I'm by myself. I mean, literally, that story I talked about early to try to give everybody else a chance, when I'm sitting and my assistant at the time is calling me and saying, what do you want me to tell them? And I'm dictating a ruling on a very important issue because the people are literally calling 4 and 5 times saying, we're sitting in a room, there's 20 of us here, it's costing approximately $30,000 an hour. We need you to decide whether this question is done or not. And I'm thinking, this is incredibly unreasonable. This is not the kind of standard I would hold myself on. If you are a person who's on the newer side, I don't want to say necessarily not, you should be able at this point to think, should I contact someone who's knowledgeable, not just to be a mentor, every one of us has had mentors, but also someone who would like to maybe be able to develop an ongoing non-ad hoc relationship. You know, we're not ready right now, but we've been talking about for the last few months about, is it ready to bring someone along? We've talked about a new lawyer or someone who wants to transition to this world, because I don't think we're ready yet for a colleague of the caliber of Tim, Julie, and Barry. But this is what we think about. And we also take very seriously, which is what I think all people should be thinking about, Katrina, is that every important organization, the American Arbitration Association, the Federal Mediation and Conciliation Services, the Bars Associations, the National Academy of Arbitrators, has this education and intergenerational obligation, and they have taken it, sometimes successfully, sometimes unsuccessfully, to bring along this next level of neutrals. I remind my colleagues, I've been the arbitrator in the nursing home industry literally for 240 nursing homes as the permanent arbitrator. It's called the impartial champion for 40 years. At every new collective bargaining agreement, I remind them I'm not going to be here forever. What is your succession plan? It's not just my succession plan. What is your succession plan? Who is the next group of arbitrators? Maybe it won't be one person. Maybe it's too much, but we can do that. So that's why I think it is sustainable. But you have to get, it's hard to make that call. It's hard to discuss it. But I would find it very odd if a successful arbitrator or mediator wouldn't be honored to at least be receiving that kind of request. He or she may not be able to do it. They may have anxiety about it. There's always this joke of Peter Seitz, who is a very famous arbitrator, wrote an article that every time I hear about a new arbitrator development program, I feel someone putting their hand in my pocket. I think exactly the opposite. And I think that if we start thinking about this, which is what you have done, Katrina, and all your colleagues, about that this is really supposed to be, a profession is supposed to make itself sustainable for the next generations. And so this kind of practice, I think, does it. But more importantly than just the education side, because I'm not educating these 3 people. They're already independently successful and would be independently successful. This, I believe, is sustainable and can be duplicated because it's better justice. It's better decision-making. I don't want to be dramatic, but more heads are better than one. And I promise you, everybody's a little immodest. They have persuaded each other and they have persuaded me that maybe you're not looking at this right. Maybe you're emphasizing it. I mean, we've had a lot of conversations. I think of the case Julie talked about because it was so encompassing. When we would talk about after the case was over and one person or the other would have a different idea of what was important and the like. Credibility, Julie mentioned today. And so, it's very, very useful to hear somebody else's perception. So yes, I do think it's sustainable. I do think it can be duplicated. And I say to all the colleagues I have who perhaps are as experienced as I am, it's not only a good idea for you, it's very important for the field, it's very important for the profession. And, and we're going to try, and, which is to come full circle about the hub, we're going to try to use our resources to help educate the next generation of neutrals. And practices like SAMS are a wonderful place for really good colleagues. Tim has a particular emphasis he wants in terms of the future. Barry has his. Julie has hers. And there's enough room for all of us. I repeat the metaphor. Experienced arbitrators shouldn't be frightened about arbitrators. They should be frightened about bad arbitrators. And so that's really the touchstone of why a practice should work together and why a practice can do more. I defy anyone to take on the kinds of issues. We're very fortunate. We have, we're deciding this week about, what 250,000 retirees are going to get in their Medicare Advantage. That's a big case. Right? You would not want that kind of decision to be decided by someone who's running from the car to their office. You'd want it for someone who has the bandwidth to be able to think about it and be deliberative about it and be able to say to someone, I read this case, but what do you think that case means? That's why you have a practice, and that's why you have people who are smart working with each other. And it's particularly good if you can do it and bring along diversity, because it's not just a societal problem, it's a professional problem here. And so we should do that. So I hope that I don't know if anybody has any other thoughts about that, but that would be my closing coda, I guess, so to speak. Barry?
One thing I would add is for the future, if there is going to be more and more regulation of the internet, there's going to be more and more litigation and more litigation that people, because of publicity, don't want to be in litigation, will go to mediation, and you'll have arbitration. And I believe that for the next generation, there's an area that will be untapped and could add to anyone's established practice by bringing along younger arbitrators who have an interest and a knowledge of the internet that more seasoned arbitrators, and I am much one of the younger people in this group, as Marty has said, he's much older much older than me. I don't care what he says. It's a year because it's a year, not months. But seriously, there is opportunities to sustain it and bring it to the next level into the future. And there are going to be many areas and opportunities for that to grow.
Just before one of my other colleagues responds, for example, for the first time now, we're doing a case involved the Fair Work Week in New York. Some of you have read about it's public, the Chipotle case. This was a law that didn't exist. And now you're going to need to have dispute resolution. You know what's going on throughout the country, especially in primarily the blue states. So there's going to be much more statutory demands for neutrals. And a practice that is already established is better able to bring on ancillary bandwidth than one that would want to start it alone or would take the chance of only going to. Julie?
I was going to mention that too, that the employment laws are changing constantly, and new developments are, make the parties have to adjust and pivot and new cases. And I think our model is going to enable us to be able to address those new claims. And I think it is something that's going to be very useful for the future.
Tim, last comment, because we're at the bewitching hour, I see.
I would say left alone, and when we're by ourselves, humans tend to be biased. They tend to be partial, uninformed, and prejudiced. And so I think the model that we have is an excellent way to cultivate diversity of thought and diversity in thought. And I think it's one way that we can all become better critical thinkers as a team. And when I think of team, I always remember together, everyone achieves more. And so that's what I think when I think of us.
Great. Thank you all so much. You've been just an amazing panel. I really appreciate the breadth and depth of all of your experience and everything that you shared. Each one of you shared something different. And it was just a wonderful experience today. I'd also like to thank our participants for joining us. Quick reminder, if you'd like to join the Hub, and that's where you can get recordings of webinars like this, as well as areas to discuss the webinars afterwards. You can join the Hub, our Scheinman Institute Employment and Labor ADR Hub, by emailing me at kn64@cornell.edu. Panelists, again, thank you. Participants, thank you. And we look forward to seeing you all again in the future.
Everybody be safe and be healthy.
All right. Bye-bye, everyone.
Thanks, Katrina.